I'm Don Linder. I'm a member of the Utah Supreme Court Advisory Committee on Professionalism, and I've served on that committee since its inception, and also served as chair of the subcommittee that wrote the Utah Rules of Professionalism. And I'd like to tell you why you should take those principles of professionalism and civility to heart. First, let me suggest that there are easy places to find those principles, one of which is the Utah Court Rules, and this is, of course, published by LexisNexis, and the rules are there as Chapter 23, entitled Standards of Professionalism and Civility. They're also in all of the usual places. The reason that I urge you to study these principles and standards is that they will help improve your practice, your relationship with your clients, and your relationships with opposing counsel. Let me tell you how. When I was a young lawyer, I thought I knew how to handle most matters that came to me. And we're doing this series, Mentor on Demand, to maybe suggest some things that will help you in the practice of law. When I was a young lawyer, I remember a client calling saying that, or actually it was opposing counsel calling, saying that he would like an extension. And I thought to myself, I knew how to handle this. I knew what to do, and I said I'd call him back in a little bit. I put the phone down, and instead of going down the hall to talk to one of the senior lawyers, I called my client up. And I said to my client, I've just been asked for an extension, and what do you think? Let me tell you something about the nature of the case so you'll get what I'm about to tell you. It was a divorce case, and my client unloaded on me, and my client said, Don, I thought you were on my side. I thought you were here to take care of my needs. Didn't I tell you that I don't want to give her a moment's time? I don't want this thing to drag out. I don't want it to go on another minute, let alone 2 more weeks. I got chewed out. What if we had a principle that said, and this is number 14, lawyers shall advise their clients that they reserve the right to determine whether to grant accommodations to other counsel in all matters not directly affecting the merits or the cause or prejudicing the client's rights, such as an extension of time, continuances, adjournments, and admissions of fact. That would give you a tool in which to shape your practice. Well, it's there. Let me tell you another story when I was a young lawyer. I thought that the rules should be strictly construed. You have 20 days in which to answer. On the 21st day, I would send a clerk over to enter the opposing party's default. And I'd wait a day or 2 more, and I'd try and get a default judgment. Well, what if you had a principle of civility that said, this is number 16, lawyers shall not cause the entry of a default without first notifying other counsel whose identity is known unless their client's legitimate rights could be adversely affected. Take these principles to heart. They'll help shape your practice. Now, what about clients? Well, an interesting thing. Principle number 2 says, lawyers shall advise their clients that civility, courtesy, and fair dealing are expected. They are tools for effective advocacy and not signs of weakness. Clients have no right to demand that lawyers abuse anyone or engage in any offensive or improper conduct. What do you do with your clients? You do what we do and what many firms do. When you send a retainer letter out to your clients, you say, enclosed is a a copy of the Utah Standards of Professionalism and Civility, which govern the conduct of all lawyers, so that they know what the rules are too. How's this going to help you in terms of your dealing with opposing counsel? Hopefully they adhere to these standards. But let me spend a minute and talk a little bit about the preamble, which is attached to the standards, so that you understand what I'm about to say about enforcement and the importance of these standards. It says in the preamble, adherence is expected to these principles as a part of a commitment by all participants to improve the administration of justice throughout this state. And it goes on to say, although for ease of usage the term court is used throughout, these standards should be followed by all judges and lawyers in all interactions with each other and in any proceeding in this state, meaning that they're to apply to administrative matters, city council, criminal cases as well as civil cases, appearances before administrative bodies, and in dealings with each other in negotiating contracts, tax matters, and the like. And you should remember that the federal courts in Utah have also adopted these principles. So how are these going to help you in terms of your relationship and dealings with other counsel? Let's take a few that are favorites of mine. Principle number 3, lawyers shall not, without an adequate factual basis, attribute to other counsel or the court improper motives, purpose, or conduct. Lawyers should avoid hostile, demeaning, or humiliating words in written and oral communications. That's pretty obvious. When you exchange drafts of orders and documents like that, the standard number 7 says, as drafts are exchanged, lawyers shall bring to the attention of other counsel changes from prior drafts. Use blacklining. Let your opponent know. It's much, much easier and much better for everyone concerned. But these standards get very specific in terms of discovery, the discovery phase. Standard number 18 deals with speaking objections. If you have an objection in a deposition, state it succinctly. Don't coach the witness as you're doing it. Standard number 19 talks about not artificially interpreting document requests and interrogatories in a restricted manner, and not obfuscating or hiding the existence of particular documents. These principles so far have been made advisory by the Supreme Court, but there's movement afoot to make them mandatory. But they're enforceable, and let me tell you how. There's a plethora of cases that talk about civility from our Supreme Court and our Court of Appeals. And those cases are very specific in terms of the same things that are in the principles of civility. If you can't do what is prohibited in our Supreme Court and our Court of Appeals, the argument simple to the trial judge or to an administrative law judge or anybody else, if you can't do it there, you can't do it here. Let me give you some examples from some cases, and we have those cases, a copy of them that we're going to put on the screen. Also, there's an article that will be in this coming month's November, December 2006 Bar Journal, in which an associate and I have written about enforcing these principles of civility. Two quick cases, Prince versus Bear River Mutual. The Supreme Court added an entire addendum to talk about uncivil behavior. They said, appellant's counsel has submitted briefs that are replete with pejorative remarks and epitaphs regarding opposing counsel, the trial court, Dr. Marble, and indirectly this court. State statements such as Bear River's arguments are supercilious, absolutely foolish, asinine, ridiculous, that Bear River is ignorant, that the trial court ignored every opinion written by this court and failed to read and comprehend the actual language of the applicable statutes, on and on and on, have no place in an appellate argument. The Supreme Court said such remarks are merely argumentative, repugnant to fundamental and rudimentary notions of civility and decorum expected of attorneys, and as we've stated before, derogatory references to others have no place in appellate briefs and are no assistance to this court in attempting to resolve any legitimate issues presented on appeal. If they have no basis in the appellate court, they have no basis in the trial court, they have no basis in administrative proceeding, they have no basis in the practice of law. A couple of other quick remarks, and we're trying to hold this to 10 minutes and I'll be done. There's a case, Advanced Restoration, by our Court of Appeals. The court went on to say derogatory references to others or inappropriate language of any kind has no place in an appellate brief and is of no assistance to this court in attempting to resolve any legitimate issues presented on appeal. Also, you should be aware that the comments to Utah Rule of Professional Conduct 3.5 tell us that we must refrain from abusive or obstreperous conduct, and that is a corollary to the advocate's right to speak on behalf of litigants. I hope you've enjoyed this summary of the principles. I hope that you will take them to heart, and I hope that you will understand how they can help you in your practice, your relationship with clients, and with opposing counsel. Thank you.